Good afternoon. Thank you all for coming today. We appreciate you being here. We were very excited to see the press release and letter from Attorney General Mike Hunter today. We've reviewed the ruling or opinion that he's offered. It is a recommendation. It is not an official Attorney General opinion. Therefore, it does not have the force of law. However, we believe that it is an accurate statement of the law. We find that the letter from AG Hunter quotes pertinent provisions of our petition that was filed last Friday, which we believe shows that we correctly stated the law and that our case is very strong. Attorney General's opinion supports the finding that the Department of Health has overstepped throughout this process. He cited specifically the marijuana leaf rules, the dispensary rules, rules regarding the limitation of locations, co-locating businesses, requiring marijuana to be grown, processed, and dispensed indoors, the bonding requirement, the hours of operations, and the THC content, all of which are things that we challenged. Attorney General Hunter also outlines that the statute specifically sets the requirements for licensing and that the Department of Health does not have the regulatory authority to exceed beyond what is in State Question 788. There was a lot of question and controversy last week about the lawsuit that we filed and it potentially delaying the implementation of State Question 788. The lawsuit asked for injunctive relief, but there was no reason it would ever delay the implementation of State Question 788. 788 has all of the necessary language in it to get licenses issued, to get businesses started, and for the Oklahoma Medical Marijuana Authority to regulate within the authority given to it in the state question. We are not prepared at this time to dismiss our lawsuit. However, we are looking forward to the opportunity to work with Representative Eccles and his legislative committee, the Department of Health, the Attorney General, and anyone else who would like a seat at the table, such as other trade organizations, to properly craft rules for medical marijuana in Oklahoma, so long as it is consistent with the will of the people and voting in State Question 788. All of us at Bussett Legal Group, not just myself, I have the distinct pleasure of being the one whose name is at the top of the letterhead, but all of us here made a group effort in working on this matter for the citizens of the state of Oklahoma, and I can't express my thanks enough for the attorneys that worked with me, particularly Patricia Podolak, who is a former Attorney General. Assistant Attorney General, thank you. G. Lynn Birch, who is a former attorney for the Department of Health, and Kelly Hensley, who are associates with my law firm, as well as the clients who were named on the petition. And in particular, Jason Emo, also known as Giddy Up. He is a well-known cannabis industry expert. He's a native of Oklahoman, and I am proud that he has chosen us to be his lawyer for his interest here in Oklahoma and for the consulting that he has given us on this lawsuit and in developing the industry in Oklahoma. Again, we're very happy with this decision from the Attorney General today, but we will continue to fight until everything is done properly.
Now, Ms. Bussett, did you have any concerns that were not addressed by the Attorney General?
There are a lot of concerns that aren't addressed. He cited specifically some of the examples that we listed in our petition. Our overall position on the petition is that the rules themselves are, one, invalid for the failure to follow rulemaking, but two, excessively exceed the scope of the authority issued to the Department of Health. Attorney General Hunter echoed a similar sentiment in the outline of his letter, talking about the authority that they had to regulate seed to sale, standards for consumptions of edibles, and the issuances of licenses.
What do you hope happens from here?
I hope that the Department of Health convenes and we institute regulations that are within the bounds of the law as it's issued. I hope that they stop trying to overstep and do things that they don't have the authority to do. I hope that if necessary, the legislator steps in and has the special session and that they honor the will of the people. One thing is for certain from all of this: the people will be heard and they will continue to speak. And if the legislature, if the state through the Department of Health or any other agency attempts to outdo or overturn the will of the people, which I have previously heard consultants say was the goal behind the No on 788 campaign, individuals will step up, they will fight, and we are happy to be the law firm leading the way on it.
So do you want 788 to stay as is, or if they are, if let's say the health department comes and says, okay, we're going to tweak this, we're going to allow this, we're going to allow the smokable, then is everyone happy, or do we want it to stay as it is, 788?
In order to implement 788, there have to be more regulations than what are specifically listed in the statute. But in order for those regulations to come into effect lawfully, the legislator has to act and either enact the legislation themselves or give the Department of Health or another state agency the rulemaking authority. They don't have it under the existing law.
What will it take for the lawsuit to be dropped?
A proper resolution and implementation of the rules under the existing authority.
Ron Durbin, the attorney that's representing Green the Vote in a separate lawsuit, is also asking for the 5 board members who voted in favor of these amendments to resign. Is that something that you would like to see as well?
I've talked to Mr. Durbin. I don't have the information that he has or has alleged. I'm not going after anyone alleging intentional wrongdoing. I haven't seen evidence of that at this point. If they do have conflicts of interest, that is certainly something that should make them consider stepping aside. I don't have that evidence, so I can't say. What I can say is that the individuals who have been appointed to this position need to do their jobs. They need to do their jobs within the law, and they need to listen and represent the people that they have been appointed to represent.
When we last spoke, you said that there was going to be a hearing on August 7th, I believe. Is that still the case?
Yes, ma'am.
Okay.
And what will take place in that hearing?
It's a hearing on the temporary injunction. We might have a full hearing at that time. The court may continue it to allow for briefing. The parties might reach a settlement. There's any number of options that could happen as a result of all of the things that have happened from here. And the one thing that we have seen with this is it's developing rapidly and will continue to do so, just as it has since Election Day.
Now, Ms. Bussett, are you representing those who are taking part in this industry, that are involved in this industry, selling, that sort of thing? Or is it a combination of the two? Some that need the medicinal marijuana for their health reasons. Is it a combination?
Yes, if you look at the pleadings that we filed the petition, there are 8 individual plaintiffs. They rep 5 or 6 of the plaintiffs are individuals who have conditions which would qualify for a medical marijuana card, and 3 of the individuals have business interests. I have other clients who aren't a part of this lawsuit that have business interests as well as patient interests. These are just the individuals that elected to be a part of this particular suit.
If the health department followed through with the recommendations that Attorney General Hunter made, would you then drop the lawsuit, or would it take more than that?
Again, the recommendations put forth by Attorney General Hunter do not address all of the problems in the regulations. The regulations have to be redone in whole, complying with the law, with the Administrative Procedures Act, with the Open Meetings Act, and within the scope of the authority granted to the Department of Health within their enabling legislation. If they don't do that, we will continue until it is done.
So basically, you're looking at the lawsuit as a fail-safe to ensure that, you know, government is being held accountable to your wishes?
Not to my wishes, but to the people of the state of Oklahoma. The state of Oklahoma has to be, the government has to be held accountable. We have seen this problem time and time again with the government, whether it's a state agency, the legislator, the governor, or someone else trying to undo the will of the people. we're not going to stand for it anymore. We're fighting this battle until what the people voted on is done and implemented.